CIV3701 Stage 2 Part 2 Actions A. Pleadings. Number 3. Possible extra steps. Further particulars and declarations. Number 3.1. Requests for further particulars. Number 3.1.1. General Overview. Further particulars for the purpose of pleadings are no longer permitted in the High Court or Magistrates' Courts. To compensate for the abolition of further particulars at the pleadings stage, the scope of High Court Rule 18 relating to the pleadings generally was expanded and Magistrates' Courts Rule 6 transformed to resemble closely High Court Rule 18. Rule 18, subsection 4 provides that from the outset all pleadings must contain sufficient particularity to enable the opposite party to reply thereto. The Magistrates' Courts Rule 6, subsection 4 has exactly the same provision. In theory, at least, this together with the other provisions of Rule 18 and 6 discussed earlier, removes the need for further particulars at the pleadings stage. Failure to observe Rule 18 or Rule 6 is deemed to be an irregular step in terms of Rule 30 or Rule 60A of the High Court and Magistrates' Courts rules respectively, a remedy which is explained in more detail later. Note, however, that further particulars may still be requested, but only after the close of pleadings, and for the purposes of trial. Further particulars for purposes of trial will be discussed in detail under pre-trial procedures. Note further that even during the pleading phase, further particulars of a limited kind may be requested by making use of High Court Rules 35, subsection 12 and 14, and the almost identical Magistrates' Courts Rules 23, subsection 13 and 15. These are not further particulars per se, but these rules do provide access to certain documents, computer disks, tape recordings, and so on, which are in the possession of the opposing party. These rules are discussed immediately below. Number 3.1.2. High Court Rule 35, subsection 12 and Magistrates' Courts Rule 23, subsection 13. Usually, access to documents, computer disks, tape recordings, and so on that are relevant to the case and in the possession of the opposing party may only be obtained after close of pleadings, as part of a discovery procedure, but is discussed later as a part of the pre-trial procedures. Rule 35, subsection 12 of the High Court Rules and Rule 23, subsection 13 of the Magistrates' Courts Rules, however, allow for the inspection and copying of documents or tape recordings, which has been interpreted to include anything on which information may be recorded, and have been referred to in the other party's pleadings or affidavits in the case of an application that have been referred to, It is not necessary to wait until the close of pleadings to demand inspection of documents or tape recordings, hereafter taken to refer to its extended meaning, which the other party has mentioned in his pleadings or affidavits. From the time a party receives a pleading that includes mention of a document or tape recording, the party is entitled to inspect that document or tape recording and make a copy or transcription. He must request inspection by serving a notice drafted in accordance with High Court Form 15 or Magistrates' Courts Form 15b. Note that the rule does not restrict the documents or tape recordings that may be inspected to those upon which the action is founded, as previously was the case under the former Magistrates' Courts Rule 15. Mere mention in the pleading is sufficient to entitle the opposing side to inspect the documents or tape recordings. However, only relevant documents or tape recordings which are not subject to privilege may be inspected. Documents or tape recordings which are not in the opposing party's possession are subject also to High Court Rule 35, subsection 12, or Magistrates' Courts Rule 23, subsection 13. But these rules will not be enforced where the opposing party is unable to obtain them. The rule applies not only to pleadings but also to affidavits used in procedures which may form part of an action, such as the summary judgment procedure discussed later. The rule applies also to documents referred to in documents annexed to affidavits. Although Rules 35 and 23 are applicable to applications as well as actions, the application of the rule to applications is not automatic and requires a prior direction from the court in terms of Rule 35 subsection 13 of the High Court Rules and Rule 23 subsection 14 of the Magistrates Court's Rules. Number 3.1.3. High Court Rule 35, subsection 14 and Magistrates Courts Rule 23, subsection 15. Once an appearance to defend has been entered, High Court Rule 35, subsection 14 and Magistrates Courts Rule 23, subsection 15 allow any party to an action to require another party to the action to make available for inspection a clearly specified document or tape recording, meaning on which information can be recorded, for the purposes of pleading. Although the document or tape recording can be obtained in terms of Rule 35, subsection 14 or Rule 23, subsection 15, need not have been referred to in the pleadings of the opposing party, as is required by Rule 35, subsection 12 and 23, subsection 13 discussed above. It must nevertheless be a specific document or tape recording which the party making use of this procedure is able to identify clearly. A vague request for a general class of documents is not permitted in terms of Rule 35, subsection 14 or Rule 23, subsection 15. Note further that in terms of Rule 35, subsection 14 or Rule 23, subsection 15, the document or tape recording must be relevant to a reasonably anticipated issue in the action. The purpose of the rule is presumably to ensure that a party is in a position to reply to pleadings, which is why it does not open the door to general discovery at this stage of the proceedings. A defendant may not use Rule 35, subsection 14 or Rule 23, subsection 15 in order to gather information needed to decide whether he has a cause of action for a counterclaim or to go on a fishing expedition, so to speak. In terms of Rule 35, subsection 14 or Rule 23, subsection 15, the document or tape recording requested must be provided within 5 days after a notice in terms of the rule has been delivered to the other party. Number 3.2. Declarations. A declaration is only necessary in actions in which a simple summons has been used. As explained earlier in our discussion of the different types of summons, a simple summons contains only a brief summary of the particulars of claim within the body of summons itself. This is perfectly adequate for the majority of cases in which such a summons is used. On balance, most such cases are open and shut and for this reason are not defended. A difficulty arises, however, with those cases that are defended, because the simple summons is not governed by Rule 18 of the High Court Rules, or the corresponding Rule 6 of the Magistrates Court's Rules, and therefore lacks the detail required in terms of Rules 18 and 6. Although the simple summons sets out the plaintiff's cause of action, it does so in concise terms, which means that the defendant often lacks sufficient detail to formulate his plea in response to the abbreviated particulars of claim. Rule 20 of the High Court Rules and Rule 15 of the Magistrates Court's Rules solve this problem. It provides that once the defendant delivers a notice of intention to defend in response to a simple summons, the plaintiff must deliver a declaration to the defendant within 15 court days of receiving the defendant's notice of intention to defend. In effect, the declaration is the plaintiff's particulars of claim, since it is identical in substance to the particulars of claim a plaintiff would attach to a combined summons. The contents of the declaration must comply with the same requirements as the particulars of claim, particularly with regards to Rules 18, subsection 4 and Rule 6, subsection 4 of the High Court's and magistrates' courts, respectively. When it comes to drafting the declaration, however, the plaintiff must ensure that there is no material variance between the abbreviated claim as set out in the summons itself and the claim as set out in the declaration. In respect of form, the declaration differs only slightly from the particulars attached to a combined summons. It has its own heading and case details conforming to those used for all the other pleadings in the action. It is described as the plaintiff's declaration between the tramlines, and it starts with a full and proper citation of the parties. The plaintiff's cause of action is set out in the same way as it would be in normal particulars of claim, and ends with a prayer in the usual manner. In terms of both High Court Rule 20, subsection 1, and Magistrates Courts Rule 15, subsection 1, the plaintiff must deliver his declaration to the defendant within 15 court days after receiving the defendant's notice of intention to defend. If the plaintiff fails to file the declaration within the 15-day period, he will not be prevented from filing it at a later stage, unless the defendant has served a notice of bar upon him, and he has failed to respond to the notice of bar. In fact, the only substantive difference between High Court Rule 20 and Magistrates Courts Rule 15 is the provision made for barring in terms of sub-rules 15, subsection 4 and 5. If the plaintiff has been barred from filing a declaration, the defendant may, in terms of Rule 31, subsection 3 in High Court matters, and Rule 15, subsection 5 in the case of magistrates' courts, apply for judgment in his favour if he is prepared to lead evidence, or for absolution from the instance if he is not prepared to lead evidence. In other words, the defendant may apply for default judgment against the plaintiff. We will be dealing with the different kinds of judgment, such as absolution from the instance, as well as with default judgments in more detail later in the book. Number 4. Responses to defective pleadings and non-compliance with the rules. Number 4.1. General overview. Having dealt with the general rules relating to pleadings, we now need to discuss the different ways in which it is possible to respond to defective pleadings and to deal with non-compliance with the rules. A thorough knowledge of the rules relating to defective pleadings is useful in that not only does one learn how to respond to such pleadings, but also how to avoid the pitfalls which may lead to one's own pleadings being defective. Knowing the procedures relating to non-compliance with the rules is useful in that it encourages one to stick to the rules when pleading. The purpose of pleadings is to define concisely and accurately the issue in a matter. Defective pleadings are those that fail to fulfill this purpose adequately or that do not comply with the relevant rules of court. It has been held that pleadings should not be approached in an overly technical and formalistic way. Nevertheless, it is dangerous to take chances with poorly drafted pleadings that do not fulfill their purpose. There are different ways in which pleadings may be defective and in which the rules of court may be broken. Although the remedies for defective pleadings or non-compliance with the rules sometimes overlap, usually they cannot be used interchangeably, and a specific procedure is prescribed for each type of defect. The following procedures may be used to attack different types of defective pleadings. Number 1. Response 1. Exception. This is the usual method of attacking a defective pleading. There are two main grounds for bringing an exception. The first type of defect in a pleading is that it fails to disclose a cause of action, when the pleading is a particulars of claim, or a defense, when the pleading is a plea. The second type of defect is that the pleading has been drafted in such a way that it is vague and embarrassing. Number 2. Response to application to strike out. Application may be made to strike out parts of a pleading which are offensive, in that they contain matter which is scandalous, argumentative, irrelevant, etc. The following procedures may be used to respond to breaches of the rules of court. Number 1. Response 3. Application to set aside an irregular step. This procedure is intended primarily for addressing technical breaches of the rules, not for dealing with faulty pleadings, although it can be used for this purpose. It provides for setting aside a procedural step taken by the opposing party which is defective in that it fails to comply with the rules. It is an occasional overlap between this procedure and the procedures for attacking defective pleadings. And number 2, response 4, enforcing compliance and condoning non-compliance with the rules. Both the High Court and Magistrates Court's rules set out procedures for enforcing compliance and condoning non-compliance with the rules. The following procedure may be used to cure certain defective pleadings. Number 1, response 5, amendment or correction of pleadings. In certain situations, a pleader may cure defective pleadings by amending them. Number 4.2, response 1, exception. Exceptions are dealt with in terms of Rule 23, subsection 1 of the High Court Rules and Rule 19, subsection 1 of the Magistrates Court's Rules, both rules being virtually identical in all material respects. An exception is a legal objection to a pleading. The objection being that the pleading as it stands is not legally valid for its purpose. It follows that if an exception is to be used, the defect should be apparent ex facie the document, that is, obvious from reading the pleading itself without recourse to external evidence. Where the fault in a pleading is apparent ex facie the pleading is said to be excipiable. The party who brings the exception is known as the excipient. If an exception is brought where the defect in the pleading is not apparent ex facie the exception itself will be bad. Because an exception attacks a fatal flaw in the pleading in question, it may result in the dismissal or setting aside of the claim or defense of the party whose pleading is being attacked. In other words, an exception may act as a knockout punch which is able to bring the proceedings to an early end without the need for the action to go to trial. Number 4.2.1. The two major grounds for taking an exception. There are two major grounds for taking an exception against a pleading. Number 1. The pleading fails to disclose a cause of action or defense, or number 2. The pleading is vague and embarrassing. Number 4.2.1. A. Failure to disclose a cause of action or defense. Since the purpose of a pleading is to define the pleader's case, failure to disclose or reveal a cause of action in your particulars of claim if you are the plaintiff, or defense in your plea if you are the defendant, is the most serious fault which may be found in a pleading. When bringing an exception, the truth of each of the allegations contained in the pleading concerned is not questioned. Even if the allegations are correct, however, the pleading may be held not to be excipiable on the basis that no claim or defense exists in law. This means that even if the evidence were laid sufficient to prove the facts set out in the pleading, no cause of action or defense would be disclosed. The plaintiff's particulars of claim should contain averments alleging that all the material facts necessary to give rise to an enforceable claim, failing which the summons is excipiable. Similarly, the defendant's plea must set out all the material facts necessary to raise a defense to the plaintiff's cause of action, failing which the plea is excipiable. The material facts, facta probanda, necessary to give rise to an enforceable claim or raise a defense, as the case may be, depend upon the nature of the particular claim involved. What constitutes the facta probanda in a particular case is a question of substantive law. For example, a claim for damages arising out of a motor vehicle collision is delictual in nature and is based on the lex equiliae. The various essential elements that need to be proven in order to sustain a claim under the lex equiliae are conduct, unlawfulness, fault, either in the form of negligence, that is culpa, or intention, that is dolus, causation, and damages. Failure to allege any one of these elements will render the plaintiff's particulars of claim excipiable. Occasionally, the courts have been prepared to draw an inference from the pleadings and accept that a necessary averment is implied. Note, however, that there is a limit to what the courts are prepared to read into a pleading. It is also worth mentioning that failure to disclose a cause of action can occur in two ways. It can occur either as a result of the failure to aver a necessary element of a claim or defense that would otherwise exist in law, or it can relate to a claim which, although fully pleaded, is misconceived in that it does not exist in law. In the latter case, the potential exception overlaps with the potential special plea. This possible overlap is dealt with in paragraph 4.2.7 below. Number 4.2.1b. Vague and embarrassing. A pleading may disclose a cause of action or defense, but may have been drafted in such a way that the pleading is ambiguous or lacks clarity. To constitute sufficient grounds for an exception, the vagueness of the pleading must be such that it will result in prejudice or embarrassment to the opposing side if it is allowed to persist. An exception based on the grounds that a particulars of claim in a specific case are vague and embarrassing strikes at the formulation of the cause of action and not its validity. For this reason, the consequences that flow from this particular defect in pleadings are less serious than a failure to disclose a cause of action or defense, as discussed above. Generally, pleadings are vague and embarrassing if they are unclear and ambiguous to the extent that the opposing party is uncertain of the case he is required to meet. For example, number 1, lack of clarity or ambiguity. A pleading is vague where a material allegation is unclear, meaningless, or ambiguous, in that it is capable of more than one meaning. A pleading may be unclear for a number of reasons. For example, where there is more than one claim, but it is not clear what relief is requested in respect of which claim. Other examples include situations which averments are unintelligible, or where the particulars of a claim are so prolix, lengthy, that it is not clear what claim or claims the defendant has to meet. An example of ambiguity would include those cases in which it is not clear whether the plaintiff is suing in contract or delict, or where there is more than one contract and it is not clear on which contract the plaintiff is suing. Number 2. The omission of material facts. Pleadings will be vague and embarrassing where material facts have been omitted, with the result that the claim or defense is rendered unclear in a material respect. Occasionally, this situation may overlap with those situations in which the omissions are not material, but merely result in a lack of sufficient particularity to enable the opposing party to reply. The two situations should not be confused. The latter situation should not be dealt with by way of exception, but by bringing an application in terms of Rule 30 for breach of Rule 18, subsection 4 in a High Court matter, and an application in terms of Rule 60A for breach of Rule 6, subsection 4 in a Magistrates Court's matter. An exception is the proper remedy when the omission is more serious. An omission is sufficiently serious to warrant an exception when it goes to the root of the claim or the defense, notwithstanding the fact that a cause of action or defense has been disclosed. The circumstances in which this kind of situation arises vary, depending on the nature of a claim. For example, failing to stipulate the date of signature of a contract or the date on which rent was due will be more material to the cause of action in a case based on breach of contract than the failure to stipulate the date of a collision in a case based on the commission of a delict. Confusion is more likely to occur in distinguishing an agreement from a series of transactions than in identifying a particular collision. In the contract example, an exception would be the correct remedy, whereas in the collision example, an application in terms of Rule 30 in the High Court or Rule 60A in the Magistrates Courts would be the proper remedy. And number 3, contradictions in the pleadings. Contradictions may result in vagueness and embarrassment in several situations. The first situation occurs when individual allegations within a particular pleading contradict each other without being pleaded in the alternative. An example is a plea in respect of a collision case in which the defendant denies being the driver of the other vehicle, but later admits colliding with the plaintiff's vehicle, claiming that he was not driving negligently. The second situation occurs when two claims or defenses contradict each other without being pleaded in the alternative, such as a claim for rent or for ejectment. This particular situation is an example of a probation and reprobation. In other words, an attempt to simultaneously enforce and cancel an agreement. A third situation occurs when a pleading contradicts another document. Examples include a contradiction between a pleading and its further particulars, or between a plea and a counterclaim, or a simple summons and the subsequent declaration. Number 4.2.2. The prejudice requirement. An exception may not be taken unless the excipient will be prejudiced if the pleading is allowed to stand. The reason for requiring prejudice is to prevent parties from taking technical objections without real substance. Since prejudice is a requirement at common law, there is no specific mention of prejudice in the rules. Essentially, prejudice constitutes the embarrassment element of a pleading that is vague and embarrassing. For this reason, it is insufficient that a pleading merely be vague. It must be vague to the extent that it is embarrassing or prejudicial before it is possible to raise an exception against it. Prejudice exists when the excipient is unable to meet his opponent's case properly due to the vagueness of the pleading. In the case of pleadings that fail to disclose a cause of action or defense, the requirement of prejudice is satisfied by the fact that a vital element is missing from the pleading. Number 4.2.3. Procedure for lodging an exception. Number 4.2.3a. The procedure in general. The procedure for bringing an exception is identical in the High Court and Magistrates' Courts. The citation is similar to other pleadings or notices. The words exception to the plaintiff's particulars of claim or defendant's plea, as the case may be, are inserted between the tram lines. The main body of the exception should clearly and concisely state the grounds upon which the exception is founded. It must be signed by counsel and an attorney in the High Court, and an attorney in the Magistrates' Courts, or by the party who is accepting in person, and it must end with a prayer for relief. Number 4.2.3b. Time periods. An exception must be delivered within the period allowed for filing any subsequent pleading. Therefore, the defendant must accept to the plaintiff's particulars of claim within the time allowed for the filing of his plea, and the plaintiff must accept to the defendant's plea within the time allowed for his replication to the plea. It is not necessary, in addition to delivering the exception, to deliver the normal pleading which the excipient would have had to deliver if he were not accepting. Number 4.2.3c. Notice. An exception based on the grounds that the pleading lacks the averments needed to sustain a cause of action or defense may be delivered without any preliminary steps. Where the exception is based on the grounds that the pleading is vague and embarrassing, however, the excipient must give the opposing party an opportunity to remove the cause of embarrassment before delivering the exception. The reason for this is to avoid the taking of exceptions in purely technical situations or in respect of pleadings that merely lack clarity. The opportunity to remove the defect is provided by the excipient serving a written notice on the opposing party. The notice must set out clearly the cause of complaint, giving the opposing party 15 court days to remove the cause of complaint and informing him that an exception will be taken if he fails to do so. The opposing party may remove the cause of complaint by amending his pleading. If he fails to do so, the excipient must deliver the exception within 10 court days from the date on which the opposing party either replies to the notice or within 10 court days from the expiry of the 15-day grace period. Number 4.2.4. The hearing. An exception is set down for hearing as an application on the opposed role. Within 5 days after delivery of the exception, the excipient should apply to the registrar for a date for the hearing. A court may defer the hearing of the exception until the trial. As the fault that gives rise to the exception must be apparent ex facie the pleading, no evidence may be heard at such a hearing. The excipient may not raise an issue that has not been set out in the particulars of the exception, or in the notice required in respect of those exceptions based on the grounds that the pleading complained of is vague and embarrassing. The onus is on the excipient to show that the pleadings is excipiable. Number 4.2.5. The consequences of failing to lodge an exception. Every litigant has a duty to take the most expeditious course to bring the litigation to finality. The prime purpose of an exception is to dispose of a matter as quickly and cheaply as possible. Should a party fail to take exception to a pleading which is clearly excipiable, and the matter subsequently goes to trial, the court may hold that he is not entitled to his costs, even though he was successful at the trial. Number 4.2.6. The consequences of a successful exception. If the exception is successful, then the pleading which was the subject of the exception is disposed of. This does not mean, however, that the action or defense of the other side is also disposed of. The court will usually grant the opposing party leave to amend the particular pleading. If that party fails to do so, then the excipient may apply to court for judgment. If at the initial hearing of the exception the court finds that there is no basis in law for the claim or the defense, it will not be possible to amend the pleading and the matter will end at this stage. Number 4.2.7. The overlap between exception and special plea. Occasionally, the circumstances that give rise to an exception overlap with those that give rise to a special plea. In these circumstances, the potential excipient may choose between raising a special plea or an exception. For example, this may occur where a plaintiff fails to establish his locus standi in the particulars of claim by failing to allege his interests in the matter. In a motor vehicle collision case, for instance, the plaintiff must allege that he is the owner of the vehicle, in respect of which damages are being claimed. Should he fail to make this averment, the defendant may raise either a special plea of non-locus standi in judicio or an exception on the grounds of failure to disclose a cause of action. Note, however, that an overlap between the two procedures will only exist where the fault is apparent from the pleading itself. If the fault is not apparent ex facie the pleading, there is no option but to raise a special plea. Another important distinction that arises from the need for the fault to be apparent ex facie the pleading is that no extrinsic evidence of the fault may be raised at the hearing of an exception. An exception is decided by legal argument based on the wording of the pleading in question. It is assumed for the purpose that the facts set out in the pleading in question are true. If it is necessary to hear extrinsic evidence in order to reveal the defect in the particular claim, then filing a special plea is a proper procedure. This will always be the case with defenses such as res judicata, since the fault will not be apparent from the pleading, making it necessary to lead evidence as to the previous action. This is also true for the absence of les pendens. Number 4.3. Response to application to strike out. The second type of procedure that may be used to attack defective pleadings is an application to strike out. This procedure provides for an offending averment to be deleted or erased from the pleading in question. Applications to strike out are dealt with in terms of Rule 23, subsection 2 of the High Court Rules and Rule 19, subsection 2 of the Magistrates Court's Rules. Rule 19, subsection 2 of the Magistrates' Court's rules is based on the corresponding Rule 23, subsection 2 of the High Court's rules, both rules being virtually identical in all material respects. Both rules read as follows. Where any pleading contains averments which are scandalous, vexatious, or irrelevant, the opposite party may, within the period allowed for filing any subsequent pleading, apply for the striking out of the matter aforesaid, and may set such application down for hearing. But the court shall not grant the same unless it is satisfied that the applicant will be prejudiced in the conduct of his claim or defence if it be not granted. In other words, there are two requirements for an application to strike out. Number 1, the offending pleading contains statements which are scandalous, vexatious, or irrelevant. And secondly, the applicant will be prejudiced in the conduct of his claim or defence if the offending statements are not struck out. As far as the first requirement is concerned, matter which may be struck out has been defined as follows. Number 1, scandalous matter. Allegations that may or may not be relevant but are worded so as to be abusive or defamatory. Secondly, vexatious matter. Allegations that may or may not be relevant but are worded so as to convey an intention to harass or annoy. And lastly, irrelevant matter. Allegations that do not apply to the matter in hand and do not contribute in any way to a decision regarding the matter. Note, however, that the meaning of irrelevant in this context is limited to matter that is irrelevant to the pleadings, rather than matter that is irrelevant to the case as a whole. Allegations of law, as opposed to allegations of fact, are irrelevant to the pleadings, even if such allegations relate to the case. Similarly, allegations relating to evidence, as opposed to allegations relating to the material facts, are irrelevant to pleadings in an action, even if the evidence may be relevant at the trial. While statements of law instead of facts may be struck out, claims or defences that are bad in law are not irrelevant for the purpose of pleading, and therefore may not be struck out, and the proper response is to raise an exception. The distinction between an exception and an application to strike out may therefore be described as follows. An exception goes to the very heart of the claim or defence, but an application to strike out attacks individual allegations which do not comprise an entire claim or defence. As far as the second requirement for an application to strike out is concerned, the prejudice need not be so great that it will reduce the applicant's prospects of success. The fact that the applicant is diverted from pursuing the main issue by having to deal with scandalous, vexatious, or irrelevant matter is probably sufficient to constitute prejudice. Note, however, that the court will not allow the use of this procedure to raise technical objections that delay the matter without any advantage. An application to strike out must be delivered within the period allowed for filing any subsequent pleading. When an application to strike out is made, it is only necessary to deliver the next pleading once the application to strike out has been dealt with. Number 4.4. Response 3. Application to set aside an irregular step. An irregular step may be set aside in terms of High Court Rule 30 and Rule 60A of the Magistrates' Court's rules. A step in the context of these rules is one that advances the proceedings one stage nearer to completion. An irregular step is a step that is in some way defective. Examples include the failure to serve summons properly, premature set down, failure to give reasons for urgency in an urgent application, or the use of a simple summons instead of a combined summons for a damages claim. Failure to comply with Rule 18 of the High Court's rules and Rule 6 of the Magistrates' Court's rules, which regulate pleadings generally, or with Rule 22, subsection 2 or 3 of the High Court's rules, and Rule 17, subsection 2, 3, or 5 of the Magistrates' Court's rules, which regulate the substantive content of pleas, is deemed to be an irregular step. Rule 18, subsection 4 of the High Court's rules and Rule 6, subsection 4 of the Magistrates Court's rules are general provisions that require all pleadings to contain sufficient particularity to enable the opposing party to reply. Failure to adhere to this rule may be met with an application in terms of Rule 30 or 60A. Furthermore, failure to include the particular averments required in terms of Rules 18, subsection 6, 8, 9, 10, and 11, and the corresponding provisions contained in Rules 6, subsection 6, 8, 9, 10, 11, and 12 of the Magistrates Court's rules also constitutes an irregular step. Examples of this include divorce particulars of claim that fail to set out the grounds on which forfeiture is claimed in terms of Rule 18, subsection 9 and 6, subsection 8, or failure to include all the averments required in respect of a claim for damages or bodily injuries in terms of Rules 18, subsection 10 and 6, subsection 9. In this context, irregular step proceedings help to compensate for the fact that further particulars for the purpose of pleadings are no longer permitted. In many cases, lack of particularity may prejudice a party's ability to reply without constituting grounds for an exception. But irregular step proceedings will provide a remedy in these circumstances. In some cases, however, a particular step taken by a party may be both excipiable, that is, subject to exception, and irregular. For example, if a plaintiff's particulars of claim fails to set out all the material facts upon which his claim is based, they will contravene Rule 18, subsection 4, or Rule 6, subsection 4, and therefore constitute an irregular step in terms of Rule 18, subsection 12, and Rule 6, subsection 13, respectively. Quite possibly, the particulars of claim will also be open to exception, since the omission of material facts may mean that no valid cause of action is disclosed in those particulars. In each case, the opposing party may choose whichever procedure he wishes to follow. There is no authority, however, to the effect that Rule 30 proceedings are designed to deal with technical as opposed to substantive defects. It is therefore preferable to take an exception in such circumstances. The required procedure to set aside an irregular step in the High Court is set out in Rule 30, subsection 2 to 4 of the High Court's rules and Rule 60A, subsection 2 to 4 of the Magistrates Court's rules, respectively. Number 1. The applicant may not himself take a further step in the matter after becoming aware of the irregular step. Number 2. Instead, within 10 court days of the applicant's becoming aware of the step, he must send a written notice to the opposing party pointing out the irregularity and giving that party 10 court days to remove the irregularity. Number 3. If the opposing party does not remove the irregularity within the 10-day period, the applicant must serve the application papers on the opposing side within 15 court days after the expiry of the 10-day period. Number 4. Once the court has heard the application, it will make an order as to what is to be done about the irregular proceedings. It has a wide discretion in terms of Rule 30, subsection 3, to set the irregular proceedings aside in whole or in part, grant leave to amend, or make any other suitable order. The court will not set aside irregularity that does not substantially prejudice the applicant. And number 5, in terms of Rule 30, subsection 4, until a party has complied with the order of the court in respect of the irregular proceeding, that party may not take any further steps in the matter. Number 4.5. Response 4. Enforcing compliance and condoning non-compliance. Both the High Court and Magistrates Court's rules contain provisions designed to enforce compliance and condone non-compliance with the rules of court. Number 4.5.1. In the High Court. Number 4.5.1a. Rule 30a. Non-compliance with the rules. High Court Rule 30 concerns itself only with the setting aside of an irregular step. Rule 30A differs from this in two ways. Firstly, it deals with all types of non-compliance with the rules generally, not just procedures that constitute steps. Secondly, its purpose is not to set aside a step, but to enforce compliance with a rule that has not been followed. An example of a situation in which this rule would be used is if a party fails to take a step he is required to take. The opposing party is able to use the procedure set out in Rule 30A to compel the defaulting party to take the necessary step. Rule 30A is a catch-all which deals with general non-compliance with the rules. It is not necessary to use this rule to enforce compliance with those rules which contain their own remedy for non-compliance. High Court Rule 30A reads as follows. Number 1. Where a party fails to comply with these rules or with a request made or notice given pursuant thereto, any other party may notify the defaulting party that he or she intends, after the lapse of 10 days, to apply for an order that such rule, notice, or request be complied with, that the claim or defense be struck out. Number 2. Failing compliance within 10 days, application may on notice be made to the court and the court may make such order thereon as to it seems meet. Number 4.5.1b. Rule 27. Extension of time, removal of bar and condonation. High Court Rule 27 is intended for the use of parties who have not complied with the rules and want the court to condone, that is, excuse, their lack of compliance. The procedure used is an application on notice to the other parties, supported by an affidavit in which the applicant must show good cause. What constitutes good cause will vary according to the circumstances of each case. It seems, however, that the court will balance two factors: the merits of the applicant's case and the applicant's default. The applicant must provide an explanation for his default in his supporting affidavit, together with a factual outline of his case in order to show that it is not unfounded or without merit. The court has a wide discretion to grant an order under this rule and will take into account not only the reasons for default and the strength of the applicant's case on the merits, but also the prejudice likely to be suffered by all the parties. The question of prejudice is irrelevant, however, if the applicant has not shown good cause in accordance with the rule. Number 4.5.2. In the Magistrates' Courts. Number 4.5.2a. Rule 60. Non-compliance with rules, including time limits and errors. Rule 60 of the Magistrates' Courts rules deals with non-compliance with rules, including time limits and errors. It is the nearest equivalent in the Magistrates' Courts rules to High Court Rule 30A, but also deals with one aspect of condonation provided for in High Court Rule 27, namely the extension of time limits. Magistrates' Courts Rule 60, subsection 2 and 3 makes provision for two different applications to the court, which represents two successive steps in a process. In terms of Rule 60, subsection 2, the court may be asked to order the opposing party to comply with a particular provision of the rules, or with a legitimate request made in terms of the rules. If the opposing party thereafter refuses to comply with the rules within the time period provided in the order, the original applicant may again apply to the court in terms of Rule 60, subsection 3, asking for judgment against the opposing party. Magistrates' Courts Rule 60 may not be used to enforce a rule that contains its own internal provision for relief. Rule 60 can be used to enforce discovery when there is no response or an inadequate response to a notice in terms of Rule 23, subsection 1. Rule 60, subsection 5, deals with the extension of time limits prescribed by the rules from the point of view of a party who has failed to keep these limits. Most time limits may be extended with the written consent of the other parties in the matter. If such parties fail to consent to the extension, the court may, on application, allow such an extension. In using its discretion to allow such an extension, a court should consider the sufficiency and acceptability of the explanation given for non-compliance. The general approach a court should adopt when making this assessment has been stated in the case of Evander Caterers Proprietary Limited versus Potgieter in the following terms. Generally speaking, a time limit in the rules of court is directed at a delay in the particular procedural step. It is not concerned with the merits of the case as such, and because of the existence of the sub-rule under consideration, it is not intended without more to deprive a litigant of his claim or defence, as the case may be. It is merely intended to prevent delay or an injustice being done, owing to delay. It would seem to follow that an extension of a time limit should not be granted as a matter of course, merely for the asking, and it should also not be lightly refused if the delay did not prejudice the other party in respect of the merits or in the conduct of his case, other than the procedural advantage gained by him owing to the existence of the time limit. Indeed, everything should be done to secure a fair trial between the parties in the litigation, so that the disputes and questions between them may be settled on their merits. In other words, although every effort must be made to comply with the time limits and requirements set out in the rules, they are not set in stone. The whole purpose behind the rules is to ensure that parties eventually get to court and present their respective cases. This spirit is reflected in Rule 60, subsection 7, which provides that no process or notice shall be invalid by reason of any obvious error in spelling or in figures or of date. Practitioners should guard against an overly mechanistic approach, in which all requests for extensions are refused, and a major issue is made out of previous typographical errors in pleadings. Note that Rule 60 has been amended, with effect from the 22nd of May 2015, to introduce Sub-Rule 9, which provides that the court may, on good cause shown, condone non-compliance with the rules. The phrase good cause is not defined, and it would seem that Sub-Rule 9 has afforded the Magistrates' Court a wide discretion to condone non-compliance with these rules. Number 4.6. Response 5. Amendment of pleadings. Number 4.6.1. General overview. Occasionally, it is necessary to amend or correct pleadings after they have been filed at courts and served on the opposing party. This may occur because of an error that came to the pleader's attention only after service, or it may occur following a successful exception or motion to strike out where the court has granted the party with defective pleadings leave to amend. An amendment may be granted at any stage of the proceedings before judgment. Amendment of pleadings is dealt with by High Court Rule 28 and Magistrates Courts Rule 55A, which are virtually identical. The sub-rules referred to in the discussion which follows refer to the sub-rules of both High Court Rule 28 and Magistrates Courts Rule 55A, which correspond exactly. Amendment in terms of these rules may take place either with the consent of the opposing party or, if there is an objection, by order of court. It is a three-stage process, with the second stage becoming unnecessary should the opposing party or opposing side raise no objection to the proposed amendment. Number 4.6.2. Stage 1. Notice of intention to amend. A party wishing to amend a pleading or document that has already been filed at court and served on the other parties must first serve a notice of intention to amend on all the other parties. This notice must set out the precise amendments intended by stating which portions of the pleadings are to be deleted and setting out the words with which the deleted portions are to be replaced. It must also call upon the other parties to deliver written objections to the proposed amendments within 10 court days, failing which the amendments will be effected. Should no objection be delivered within this time, the other parties are deemed to have consented to the amendment. Consequently, Stage 2 falls away and the party wishing to amend the pleadings proceeds straight to Stage 3. Number 4.6.3. Stage 2. Objecting to the amendment. If, after receiving the notice of intention to amend, one of the parties wishes to object to the proposed amendment, the objector needs to clearly and concisely state the grounds upon which the objection is founded. Having received such an objection within the 10 court days referred to in Subrule 2, the party wishing to amend must make application on notice of motion to court within 10 court days of receipt for leave to amend. The matter will then be set down for hearing as would any interlocutory application. The court will usually lean in favor of granting the proposed amendment. After all, the purpose of pleadings is to allow a proper airing of the dispute between the parties, which may only be possible if the amendment is permitted. The onus is on the applicant to show that the amendment should be permitted. The main consideration for the court in permitting an amendment is that the other parties should not be prejudiced in a manner that cannot be corrected by an order for a postponement of proceedings if necessary, and costs against the applicant. With regard to prejudice, the applicant's burden to persuade the court to allow an amendment becomes greater depending on the extent of the inconvenience and dislocation caused to the other parties. A further consideration is whether the amendment introduces something worthy of consideration. A triable issue rather than a groundless rather than a groundless issue that will merely harass the opposing party. A triable issue is one which, if it can be proved by the evidence prospectively set out in the application for the amendment, will be viable or relevant, or which, as a matter of probability, will be proved by the evidence prospectively set out in the application. The bona fides good faith of the applicant in requesting the amendment is also of importance. With respect to bona fides, the reason for the amendment is considered, whether, for instance, it has been occasioned by an honest error or an attempt to secure a tactical advantage. An example of securing a tactical advantage mala fide would be to request an amendment to include a new cause of action, which the applicant had deliberately refrained from raising at the start because he wished to cross-examine his opponent's witness before including it in the particulars of claim. The criteria the court applies when deciding whether to permit an amendment have been summarized as follows. The practical rule seems to be that amendments will always be allowed unless the application to amend is mala fide, or unless such amendment would cause an injustice to the other side which cannot be compensated by costs. In other words, unless the parties cannot be put back for the purposes of justice in the same position as they were when the pleadings which it is sought to amend were filed. Usually, the application need not be accompanied by a supporting affidavit, apart from situations in which a full explanation is required to convince the court of the applicant's bona fides. An amendment correcting spelling, arithmetical or clerical errors, or amendments that remove ambiguities and correct pleadings that are vague and embarrassing usually would not involve the applicant's bona fides as an issue. The applicant's bona fides becomes an issue in the case of more serious forms of amendment, such as when the applicant wishes to withdraw an admission. While the considerations usually applied by the court remain the same, that is, prejudice and its avoidance by way of a costs order and postponement, together with the consideration of mala fide, the courts are less likely to grant this kind of amendment. This is because the applicant's change of attitude with regard to the admission calls for an examination of his bona fides. His reasons for requesting the amendment are not self-evident and will need explanation. Also, the potential for prejudice is far higher in the kind of case in that if the amendment is allowed, the opposing side will be obliged to gather evidence in support of the allegation which was admitted, but then placed in dispute again by the amendment. In this kind of case, the supporting affidavit needs to set out the circumstances under which the pleading was originally drafted, and the reasons for which the amendment is now requested. Other examples of more serious amendments would be when the proposed amendment introduces a fresh cause of action, and amendments that alter the original parties to the action. Note also that an amendment which renders the pleadings excipiable will be refused. Number 4.6.4, Stage 3, Giving effect to the amendment. In terms of Subrule 5, if none of the other parties objects to the amendments proposed in the Notice of Amendment, the party proposing the amendment may effect, that is, carry out the amendment within 10 court days after the expiry of the period allowed for objection. Alternatively, the amendment may be effected within 10 court days of the courts authorizing it as a result of an application referred to in Stage 2 above. In terms of Subrule 7, an amendment is effected by filing the amended pages at court and serving them on the opposing party. The amended pages are pages that reflect the alterations indicated in the Notice of Amendment delivered during Stage 1. These amended pages replace the original pages. Once an amendment to a particular pleading has been effected, the other parties may want to change their pleadings in response to the amendment. Subrule 8 provides that the opposing party may, within 15 court days after the amendment has been effected, make any consequential adjustment he wishes to his own pleadings. Should the opposing party fail to do so, Rule 22, subsection 3 will apply, and every allegation of fact that has not been denied will be deemed to have been admitted. He is also entitled to raise an exception to, or make an application to strike out, portions of the amended pleading, or to make application to have it set aside as an irregular step in terms of High Court Rule 30 or Magistrates Courts Rule 60A. Number 5. Shortcut judgments. Number 5.1. General overview. It is not always necessary to wait until a trial has been held in order to obtain judgment. In the following situations, it may be possible to obtain judgment before the matter goes to trial. Number 1. A default judgment. The plaintiff may apply for default judgment against the defendant if the defendant fails either to enter an appearance to defend or to plead after being warned that he may be barred if he fails to do so. Default judgment may also be taken against a party who fails to appear at the trial, as well as in certain other circumstances. Number 2. Summary judgment. If a plaintiff has a particularly clear-cut claim, one of a number specified in the rules, he may apply for summary judgment if it is clear that the defendant has no valid defense and is simply entering an appearance to defend in order to delay the matter. And number 3, confession of claim or consent to judgment. Judgment may be taken against a defendant who has consented to judgment being taken against him. We refer to the above as shortcut judgments. Let us examine each one in turn. Number 5.2, Shortcut Judgment 1, a default judgment. Number 5.2.1, Overview. There are two main forms of default that may result in judgment: default of appearance and default of pleadings. Although a number of possible default situations are dealt with below, those most frequently encountered in practice are a failure on the part of the defendant to enter an appearance to defend at all, or b, after entering an appearance to defend, a failure to plead after he is warned that he may be barred if he fails to do so. Apart from certain minor differences indicated below, the procedures involved are broadly similar in the High Courts and Magistrates' Courts. Number 5.2.2, Default of Appearance. Number 5.2.2a, Defendant's default of appearance to defend. In terms of High Court Rule 31, subsection 2a and 31, subsection 5a, and Magistrates' Courts Rule 12, subsection 1a, default judgments may be granted against a defendant if he fails to deliver a notice of intention to defend within the time set out in the summons, this indicia. This is the most common situation resulting in default judgment. Practitioners should note that where an order is sought declaring residential property specially executable, the registrar can no longer hear the matter and must refer it to court. This is in accordance with the Constitutional Court decision in Gondwana versus Steco Development and others, and Jafta versus Skuman and others, also Van Rooyen versus Stolz and others, which found that the rules and practice allowing registrars to declare mortgaged property specially executable after default judgment on money debt unconstitutional for lack of judicial oversight. Number 5.2.2b. Plaintiff's default of appearance at trial. Comparate default. High Court Rule 39, subsection 3 and Magistrates Courts Rule 32, subsection 1 apply to failure on the part of the plaintiff to appear at trial. In terms of Magistrates Courts Rule 32, subsection 1, if the plaintiff fails to appear at the trial, the court may dismiss the action with costs. The word may indicates that the court has a discretion whether or not to dismiss the action. The words plaintiff and defendant include the attorneys of the respective parties. This means that the parties will not be held to be in default provided that their attorney are present in court. Dismissal in this context means absolution from the instance rather than a final judgment and cannot be pleaded as res judicata. High Court Rule 39, subsection 3 makes provision for the termination of the plaintiff's claim in circumstances outlined above. The rule specifically refers to absolution from the instance and is therefore very similar in effect to the Magistrates Court's rule. However, it contains an added proviso to the effect that the defendant may lead evidence with a view to satisfy the court that final judgment should be granted in his favor, and the court, if so satisfied, may grant such judgment. However, the court will not grant final judgment lightly. There must be special circumstances, such as deliberate default on the part of the plaintiff. Number 5.2.2c. Defendant's default of appearance at trial. In terms of Rule 32, subsection 2 of the Magistrates Court's rules, the plaintiff may apply for judgment with costs if the defendant fails to appear at the trial. In order to properly exercise its discretion, the court may need to hear evidence. This will be the case when determining the quantum of the claim, should the action be for an unliquidated amount of money. High Court Rule 39, subsection 1 is the corresponding rule in High Court practice. It provides that if the defendant does not appear, the plaintiff may prove his claim so far as the burden of proof lies upon him and judgment will be given accordingly, insofar as he has discharged that burden. It adds the proviso that where the claim is for a debt or liquidated demand, no evidence shall be necessary unless the court otherwise orders. Number 5.2.3. Default of pleadings. Number 5.2.3a. Default of plea. Default of plea is the most important kind of default relating to pleadings. In March 2016, Rule 12 of the Magistrates Court's rules was amended, and in 2014, Rule 21b of the Magistrates Court's rules was introduced, as a result of which the High Court and Magistrates Court's rules on this particular topic are nearly identical in effect. Nevertheless, the procedure followed in each court will be dealt with separately to avoid confusion. Number 5.2.3a.1. Default of plea, High Court. With default of plea, the defendant has given notice of his intention to defend the action, but has failed to deliver his plea within the prescribed period set out in High Court Rule 21, subsection 1. The plaintiff then serves a notice of bar on the defendant in terms of Rule 26, calling on him to deliver his plea within 5 days. Should the defendant fail to do so, he is in default and is ipso facto barred from pleading. From this point on, the procedure is almost the same as if the defendant were in default of appearance, and the plaintiff may apply for default judgment in terms of Rule 31, subsection 2 or 5. There is one important difference in that notice of the application for default judgment must be served on the defendant in terms of Rule 31, subsection 4 and 5. Note that Rule 31, subsection 2a does not mention that a notice of bar is required. The sub-rule uses the words in default of delivery of a plea, which has a technical meaning in this case. In terms of Rule 26, a defendant will only be in default of delivering his plea once the time period stipulated in the notice of bar has expired. It is for this reason that once a notice of intention to defend has been filed, default judgment may only be applied for after the service of a notice of bar and the expiry of the time period set out in that notice. Number 5.2.3a2. Default of plea magistrates courts. In terms of Magistrates Courts Rule 12, subsection 1b, if a defendant enters an appearance to defend but fails to deliver a plea within the prescribed time limit, then the plaintiff may serve a notice of bar on the defendant. This notice of bar will call upon the defendant to deliver a plea within 5 days from the date of receipt of the notice, failing which the defendant will be in default of the plea and ipso facto, that is, automatically barred. The plaintiff will then be entitled to apply to the clerk of the court for default judgment against the defendant. The effect of this rule is identical to that of High Court Rule 26 as it relates to the defendant's plea. One difference in respect of the subsequent default judgment application, however, is that no further notice need be given to the defendant. Number 5.2.3 A3. Default of plaintiff's plea in reconvention. In High Court practice, the procedure in respect of the plaintiff's failure to deliver his plea in reconvention to the defendant's counterclaim on time is identical to the barring procedure used in respect of the defendant's plea in convention. In High Court practice, the barring procedure provided for in High Court Rule 26 covers all pleadings, which of course includes a plea in reconvention. With the introduction of Rule 21b in 2014 and its amendment in 2016, which provides for a general barring rule covering all types of pleadings, the position is now identical in Magistrates' Courts practice. Accordingly, Rule 21b of the Magistrates' Courts rules eliminates a lacuna which existed as a result of the 2010 amendments to the Magistrates' Courts rules, as discussed in the second edition of this book. Number 5.2.3 B. Default of declaration. Default of declaration is an example of the plaintiff being in default of pleading, and the defendant being in a position to apply for default judgment. If the plaintiff's claim is for a debt or liquidated demand, he will usually issue a simple rather than a combined summons. Once the defendant has given notice of his intention to defend, the plaintiff must deliver a declaration within 15 days of receipt of such notice in terms of High Court Rule 20, subsection 1 and Magistrates' Courts Rule 15, subsection 1. If he neglects to do so, the defendant may serve a notice of bar on him in terms of High Court Rule 26, demanding that the declaration be delivered within 5 days. Should the plaintiff still fail to do so within this period, he is automatically barred. With the plaintiff barred from any further pleading, the defendant may set the action down in terms of High Court Rule 31, subsection 3, and apply for absolution from the instance or after adducing evidence for judgment. Provision is made in terms of Magistrates' Courts Rule 15, subsection 5 for exactly the same remedy and result where a plaintiff has been barred in terms of Rule 21b, subsection 3, from delivering a declaration. Number 5.2.4. Applying for default judgment. Where either the plaintiff or defendant failed to appear at the trial in either the High Court or Magistrates' Courts, application for default judgment is made orally from the bar. The procedures to be adopted in all other cases are dealt with below. Number 5.2.4a. The procedure in the High Court. The first question the plaintiff must ask himself is whether or not his claim is for debt or liquidated demand. A debt or liquidated demand is a claim for a fixed, certain, or ascertained amount or thing. For example, a claim for goods sold and delivered is a debt or liquidated demand, whereas a claim for damages arising out of a motor vehicle collision is an unliquidated claim. Where the claim is not for a debt or liquidated demand, the court itself will have to hear the application for default judgment. Where the claim is for a debt or liquidated demand, however, the application for default judgment may be considered administratively by the registrar of the court. This means that the application for default judgment is lodged with the registrar who deals with it in chambers, without the plaintiff or his legal representatives present. The reason for this administrative procedure is that claims involving debts or liquidated amounts are often very straightforward. By allowing applications for default judgment involving such claims to be decided by the registrar, the rules have reduced the burden of work placed on the courts. Let us examine each type of claim and the procedure required in turn. Number 5.2.4a1. If the claim is not for a debt or liquidated demand. If the claim is not for a debt or liquidated demand, that is, an unliquidated claim, then the plaintiff must set the matter down for hearing by the court where the application will be moved formally by counsel. The reason that such matters must be heard by the court is that the plaintiff has to satisfy the court as to the quantum of his damages. The court may also, in its discretion, allow the plaintiff to lead evidence by affidavit to prove his cause of action in a damages claim. Although default judgment is granted in relation to an action rather than an application, the matter is always heard in motion court because the application procedure is used to obtain default judgment. In undefended matrimonial actions where the matter is set down for default judgment, however, the plaintiff must attend court and briefly give evidence to verify the facts constituting the cause of action in the summons. If the defendant has failed to enter a notice of intention to defend, then no notice of set down of the application for default judgment need be given to the defendant in terms of High Court Rule 31, subsection 4. If the defendant has failed to plead and then ignored a notice of bar, however, the notice of set down must be given to the defendant at least 5 court days before the hearing. The reason for the difference in approach is apparent. If the defendant has not bothered to enter an appearance to defend, there is no reason why the plaintiff should be put to the bother and expense of giving the defendant notice of the application for default judgment. If the defendant has at least taken the trouble to enter a notice of intention to defend, but then has failed to do anything further, he is entitled to the benefit of the doubt and must be given notice of the application for default judgment. After hearing evidence, the court will grant judgment or make an order which it considers fair. Number 5.2.4 A2. If the claim is for a debt or unliquidated demand. If the claim is for a debt or liquidated demand, the plaintiff must file a written application for judgment against the defendant with the registrar. Note that a plaintiff is obliged to apply for judgment to the registrar where the claim is for a debt or liquidated demand, and may not make application to the court. If the defendant has failed to enter a notice of intention to defend, the notice of the application to the registrar need not be given to the defendant. If the defendant has failed to plead and has then ignored a notice of bar, however, the notice of application to the registrar must be given to the defendant at least 5 court days before the application is made. Note that this is a notice of intention to apply for default judgment, not a notice of set down. This is because all claims for a debt or liquidated demand are now dealt with by the registrar administratively in chambers, and therefore at his convenience without the plaintiff or his representative present. It is therefore impossible either to set the matter down for hearing or even to know when the matter will be heard by the registrar. The notice of intention to apply for default judgment should therefore give 5 days' notice of the date on which the matter will be lodged with the registrar. The registrar may grant judgment as requested or grant judgment for part of the claim only or on amended terms, or refuse judgment wholly or in part, or postpone the application for judgment on such terms as he may consider just, or request or receive oral or written submissions, or require that the matter be set down for hearing in open court, provided that if the application for an order declaring residential property specially executable, the registrar must refer such application to the court, as discussed above. The registrar will require the matter to be set down for a court hearing if he is of the opinion that evidence is required either as to the quantum or the merits of the claim, or he has doubts about granting judgment. Although the courts have invariably granted judgment by default on a debt or liquidated demand without hearing evidence, they retain the discretion to demand evidence on any point should they deem it to be necessary. If a party is dissatisfied with the judgment or directions of the registrar, he may, within 20 days after he has acquired knowledge of the judgment or direction, set the matter down for reconsideration by the court. It is not clear how an application for reconsideration by the court of a default judgment given by the registrar will differ from an application for rescission of a default judgment given by a court in terms of Rule 31, subsection 2b, although it is clear the requirements are different. Rule 31, subsection 2b is only available to a defendant, not a plaintiff. It prescribed a 20-day period after obtaining knowledge of the judgment within which to make application, and it requires that good cause be shown. The safest course of action for the defendant to adopt in the former case may be to treat an application for reconsideration in the same way as an application for rescission. As far as the costs are concerned, if the claim falls within the jurisdiction of the magistrate's courts, the registrar will grant a judgment for R200 costs plus sheriff fees. If the claim is outside the jurisdiction of the magistrate's courts, then the registrar will grant a judgment for R650 costs plus the sheriff fees, unless the application for default judgment specifically requires the cost to be taxed, or the registrar decides that the court should decide the issue of costs. Number 5.2.4b. The procedure in the magistrate's courts. In the magistrate's courts, if the defendant defaults in that he fails to enter an appearance to defend or fails to plead after being called upon to do so in a notice of bar, the plaintiff may request default judgment against him in terms of Magistrate's Courts Rule 12. Ordinarily, request for default judgment is not heard in open court unless, as indicated previously, it is made in respect of failure to appear at trial, when it is applied for orally from the bar. In all other cases, the plaintiff merely lodges a written request for judgment by default with the clerk of the court. The request must be drafted to conform to Form 5 of the Magistrates' Courts Rules and must be signed in duplicate, which, strictly speaking, means 2 original signed drafts and not 1 original plus a copy. In practice, the relevant particulars are typed onto a printed form or, more likely these days, added to a computer-generated precedent. The original summons and the sheriff's return of service should be attached to the application. These documents will still be with the plaintiff's attorney, as the clerk of court no longer opens a court file when summons is issued in the magistrate's courts, but only when the matter proceeds further. Note that in terms of Rule 12, subsection 3, default judgments may only be obtained on a summons served by way of registered post if an acknowledgement of receipt referred to in Rule 9, subsection 13a has been filed by the sheriff with his return of service. Requests for default judgment in the magistrates' courts under Rule 12 are all dealt with administratively in chambers, and because the plaintiff's attorney is not present, he will only learn of the outcome when the request requests are returned, duly endorsed with the judgment or otherwise. In the case of liquid claims, for example, for goods sold and delivered, the clerk of court grants judgment himself in terms of Rule 12, subsection 1c, the job being delegated at bigger centres such as Durban to judgment clerks. They will peruse the particulars of claim to check that the cause of action for the claim which is set out in the request for default judgment is disclosed in the particulars of claim. In the event that default judgment has been applied for after the defendant's failure to enter an appearance to defend, the judgment clerk will also check that there has been proper service of the summons on the defendant. Only if all appears to be in order will he grant judgment, and thereafter inform the plaintiff's attorney by sending back the request endorsed with a stamp indicating that judgment has been granted together with the date. If the application is based on a liquid document, this document must be filed before judgment is entered in terms of Rule 12, subsection 6. Where the claim is for an unliquidated amount, for example, damages to a motor vehicle resulting from a collision, default judgment will not be granted by the clerk of the court. Instead, the matter will be referred to the court, which will assess the amount recoverable by the plaintiff and give the appropriate judgment. Although Rule 12, subsection 4 refers to the court, the matter is not heard in open court. The clerk places it before a magistrate who deals with the matter administratively in chambers, usually without any of the parties being present. In terms of Rule 12, subsection 4, the courts will require some form of evidence, either written or oral, as to the nature and extent of the claim before it will grant default judgment. Although evidence may be given orally, a request for default judgment in respect of an unliquidated amount is usually supported by an affidavit in which full details are given as to the manner in which the claim was quantified. This is generally referred to as a damages affidavit. Note that a claim for an unliquidated amount is not restricted to a claim for damages. For example, a claim for unjust enrichment would constitute a claim for an unliquidated amount. Note also that while a damages claim is the prime example of an unliquidated claim, it may become liquidated by agreement. Finally, note that it is important that the person who deposes to the damages affidavit is the person who actually assessed the damages. If the deponent is an expert, he must lay a basis for the averment that he is an expert, just as he would if he were giving oral evidence. It would not be adequate, for example, to attach an affidavit deposed to by the owner of a garage in which he states that the vehicle in question in a collision case has been repaired. A damages affidavit is required in order to place evidence concerning the nature and extent of the damages before the court, sufficient to enable the court to assess the damages. An example is a damages affidavit by a panel beater, in which he sets out his qualifications and experience, and certifies that the amount of a claim for damages to a particular motor vehicle which he has examined is fair and reasonable. In any request for judgment on a claim arising out of a credit agreement governed by the National Credit Act or the Credit Agreements Act 75 of 1980, the request must also be referred to the court in terms of Rule 12, subsection 5. Number 5.2.5, Borrowing. Number 5.2.5a, General Overview. The concept of borrowing is often associated with default judgment, but is of wider application. Borrowing is a procedure that prevents the delivery of any further pleadings in an action by placing them under bar. In some situations, borrowing is automatic. In others, it requires the delivery of a notice of bar. Borrowing is seldom fatal to a case if the borrowing is automatic, as this kind of borrowing affects only the non-essential or rather non-optional types of pleadings and does not lead to a default judgment situation, for example, replication. The danger of default judgment is always present. However, wherever a notice of bar is used. It is for this reason that the topic of barring has been raised at this particular point. Barring is dealt with under Rule 26 of the High Court's rules, which is a general rule dealing with barring. Rule 21b is a direct equivalent in magistrates' courts practice. Number 5.2.5b, automatic barring. Automatic barring is provided for in High Court Rule 26 and Rule 21b of the Magistrates' Court's rules. After the defendant serves his plea on the plaintiff has 15 days in which to serve his replication to the plea on the defendant. If he does not do this, then in terms of Rules 26 of the High Court Rule and 21b of the Magistrates' Court's rules, respectively, he will be ipso facto or automatically barred. What this means, in effect, is that the pleadings are deemed to be closed and the matter may be set down for trial. This also applies to all the pleadings that follow the replication. For example, if the plaintiff delivers his replication within the time limit, but the defendant fails to deliver his rejoinder within the time limit, the defendant will automatically be barred from further pleadings. Unless there is a specific need to file a further pleading, failure on the part of either the plaintiff or defendant to file such further pleading merely serves to close the pleadings and does not constitute an admission of the facts in the previous pleading. Rule 21 of the Magistrates' Court's rules deals with replications and was amended in 2010, so as to duplicate almost exactly Rule 25 of the High Court's rules. This means that unlike the solitary reply to a plea previously provided for in Rule 21, the whole gambit of the replication and rejoinder pleadings are now permissible in High Court's practice. As noted above, Rule 21b of the Magistrates' Court's rules now provides a general rule for barring equivalent to Rule 26 of the High Court rules, which includes a method of automatic barring if these pleadings are necessary and are not served on time. Number 5.2.5 C. Notice of bar. In terms of High Court Rule 26, there is no automatic barring in respect of pleadings that come before the replication. These pleadings are the plaintiff's declaration, the defendant's plea, and the plaintiff's plea in reconvention to any counterclaim in High Court practice. If any of these pleadings is not delivered on time and a party wishes to obtain default judgment against the defaulting party, he must serve a notice of bar on that party. The notice of bar calls on the defaulting party to deliver the declaration or plea within 5 court days after receipt of the notice. If the defaulting party does not deliver the declaration or plea within the 5-day period or within a further agreed period, the defaulting party is ipso facto barred from doing so thereafter, and the other party may apply for default judgment against him. Notices of bar are most commonly served by plaintiffs on defendants who have failed to deliver their pleas in time. Barring a party from pleading is a serious threat to that party's case, as the next step is to apply for default judgment against the party who has been barred. An important point to bear in mind is that in terms of the proviso to High Court Rule 26, the days between the 16th of December and the 15th of January, both inclusive the dis non, shall not be included in the time allowed for the delivery of any pleading. For example, assume that a notice of bar is delivered to the opposing party on the 15th of December. The notice requires delivery of the opposing party's pleading within 5 court days after service of the notice of bar upon him. Because of the dis non, the opposing party will only have to deliver the pleading within 5 full court days after the 15th of January. Magistrates' courts previously never had a period of recess, and the dis non limitation of High Court practice has never applied. Nevertheless, the 2010 amendments introduced the dis non limitation into magistrates' courts practice with regard to notice of intention to defend in terms of Rule 13, subsection 1, and delivery of any pleading in terms of Magistrates' Courts Rule 21b, subsection 3. Number 5.2.5d. Removal of bar. In the High Court, a bar may be removed in terms of High Court Rule 27. Any attorney who has been careless enough to have his pleadings barred must adopt the following procedure in order to remove the bar. He may first ask the other party if they will agree to the bar being removed. If the other party agrees, the bar is duly removed. If the other party refuses to agree to the removal of the bar, however, then the defaulting party may apply to court on notice, as opposed to on notice of motion, in terms of Rule 27, subsection 1 of the High Court Rules, for the bar to be removed. The non-defaulting party is not obliged to agree to the removal of the bar, although unreasonable opposition to the subsequent application may well attract an adverse cost order. In order for the defaulting party to succeed in his application, he will have to show good cause. Harms lists the following situations in which the court will tend to grant the application to lift the bar. Number 1. The applicant has given a reasonable explanation of his delay. Number 2. The application is bona fide and not made with the objection of delaying the opposite party's claim. Number 3. There has not been a reckless or intentional disregard of the rules of court. Number 4. The applicant's action or defense is clearly not ill-founded. And number 5. Any prejudice caused to the opposite party can be compensated for by an appropriate order as to costs. In addition to the provisions set out in Rule 27, the High Court have inherent jurisdiction to remove the bar. There is no specific procedure for raising a bar placed on pleadings in the magistrate's courts, but the defendant may apply for an extension of time in terms of Rule 60, subsection 5. Number 5.3. Shortcut Judgment 2. A summary judgment. Number 5.3.1. General overview. In the case of an application for default judgment, one is dealing with a situation in which the defendant usually does not put up any opposition, in that either he does not enter an appearance to defend or fails to respond to a notice of bar. In the case of an application for summary judgment, however, one is dealing with a situation in which the defendant does oppose the matter, but there is a suspicion that the only reason for the defendant's opposition is to delay the matter. The rules provide a mechanism whereby a plaintiff who finds himself in this situation may attempt to shortcut the usual procedures and obtain judgment without having to go to trial. The very nature of the summary judgment procedure is extraordinary, in that it allows the court to grant a final order in a defendant action without the parties going to trial. The purpose of the procedure is to prevent the defendant from delaying the proceedings when he has no real defense to the plaintiff's claim. There is an attempt to balance two conflicting interests. On the one hand, the plaintiff should not be forced, in circumstances which amount to an abuse of the process of court, to suffer the delay and expense of a trial. On the other hand, summary judgment is a severe and extraordinary procedure which circumvents the odi alteram partem principle, in that a defendant who wishes to defend a matter may have judgment taken against him without the benefit of a trial. Summary judgment will therefore only be granted where a court is satisfied that the plaintiff has a very clear case and the defendant fails to establish a bona fide defense. There are several provisions in the rules which help to keep these competing interests in balance. Summary judgment is a frequently used procedure and therefore of great importance. The provisions regulating summary judgment are found in Rule 32 of the High Court's Rules and Rule 14 of the Magistrates Court's Rules. The provisions regulating summary judgment in the High Court Rules and Magistrates Courts have always been very similar, but the 2010 amendments to Rule 14 of the Magistrates Court's Rules have made them virtually identical. Number 5.3.2. Permissible claims. Because summary judgment is such a drastic remedy, only the clearest and most straightforward claims may be subject to a summary judgment application. The types of claim permitted are all liquid in nature. Note also that not all types of liquidated claims are permitted, but only the four specifically listed in High Court Rule 32, subsection 1 and Magistrates Courts Rule 14, subsection 1. In terms of these rules, a plaintiff may only apply for summary judgment together with any claim for interest and costs if his claim is: first, based on a liquid document; secondly, for a liquidated amount in money; third, for delivery of specified movable property; or fourth, for ejectment. Let us deal with each type of claim in turn. Number 5.3.2 A. On a liquid document. Examples of liquid documents include checks, acknowledgements of debts, and mortgage bonds. In the context of summary judgment, the term liquid document has the same meaning as in the provisional sentence procedure and is dealt with in detail in that section. Erasmus points out that even if a document does not fall precisely within the parameters of a liquid document, it is of little importance for the purposes of summary judgment. This is because the document is still likely to lead to a liquid claim under the next category, that is, a liquidated amount in money. Of course, many liquidated documents, such as checks, are sued for by way of provisional sentence summons, where summary judgment does not apply. However, there is nothing to prevent a plaintiff from using a simple summons or even a combined summons to sue on a claim based on a liquid document in the High Court. Number 5.3.2b. For a liquidated amount in money. A claim need not be evidenced by a document at all in order to be liquidated. In fact, a liquidated claim may arise out of an oral agreement, such as a claim for arrears rent arising out of an oral lease. A debt or liquidated demand, as noted in the sections dealing with simple summonses and default judgment, may be defined as a claim for a fixed or definite thing. For example, a claim for the transfer of immovable property or ejectment, for cancellation of a contract, for delivery of goods, or for the rendering of an account by a partner. A liquidated amount in money, however, only involves money claims and does not include debts or liquidated demands requiring an act on the part of the defendant, such as the delivery of property, transfer, or the like. Such a claim must be based on an obligation to pay an agreed sum of money or is so expressed that the ascertainment of the amount is a mere matter of calculation. In Fatty's Engineering Co. Proprietary Limited versus Vendic Spares Proprietary Limited, it was held that a claim for work done and materials supplied, a claim based on a quantum merit, fell within the category of a liquidated amount in money as the reasonable remuneration for the work and the market price of the materials were known and therefore ascertainable. On this reasoning, a claim for professional services rendered would also pass muster. In KwaZulu-Natal, however, a stricter approach has been followed and the claim must be based on an obligation to pay an agreed sum of money, or an amount that can be ascertained merely as a matter of calculation. There are Western Cape decisions that go both ways, but appear to favor Fatty's approach on balance. At the very least, however, a liquidated amount in money would include claims for the purchase price of goods sold and delivered, monies lent and advanced, arrear rent, a taxed bill of costs, etc. To this must be added the further proviso that these claims may only be for money and may not be coupled with claims requiring an act such as specific performance. This is apart from the two categories that follow. Number 5.3.2c. For delivery of specified movable property. Delivery of specified movable property is one of the two types of liquid claims requiring an act. as opposed to the payment of money, in respect of which an application for summary judgment may be brought. Although claims for specific performance are usually heard in the High Court, this is one of the exceptions permitted in the Magistrates' Courts in terms of Section 46 of the Magistrates' Courts Act. Note that it is a claim for the delivery of movable property which is permitted here, not a claim for the transfer of immovable property. Claims such as this are occasionally accompanied by either by a claim for damages or an alternative claim for the value of the property. As both these types of claims are unliquidated, a court would grant summary judgment on the claim for delivery but refuse summary judgment on the accompanying claim. Number 5.3.2d. For ejectment. This is a claim requiring the removal of the defendant from premises unlawfully occupied, and is another example of a liquid claim which does not involve a demand for a liquidated amount in money. It may, however, accompany a claim for money. If the accompanying money claim is an unliquidated claim for damages, such claim will not be granted at summary judgment stage, but if it is a liquidated amount in money, summary judgment may be granted in respect of both claims. The most common example would be a claim brought by a landlord against a tenant for arrears rent, accompanied by a claim for ejectment from the leased premises. Summary judgment may be granted for both these claims. Summary judgment should not be granted, however, in respect of a further claim brought by the landlord for the costs of repairing the damage allegedly caused to the leased premises by the tenant. Claims for interest and costs are ancillary to the main claim. Summary judgment may be granted in respect of these claims. The normal principles governing costs and interests apply. Interest may be claimed from the date the defendant is in mora, that is, the date when the debt fell due. In the case of a liquidated amount of money, this would usually be a date agreed by the parties. If the plaintiff has a number of claims, some of which fall into the categories above and some of which do not, he may apply for summary judgment in respect of those claims that qualify, and allow the other claims to proceed to trial. Number 5.3.3. The application. The procedure followed is by way of application, moved in motion in courts in terms of High Court's Rule 32 subsection 2 and Magistrates Court's Rule 14 subsection 2. Number 1. Should the plaintiff wish to apply for summary judgment, he must approach the court by way of notice of motion within 15 days of receiving the notice of intention to defend. If application is not made within the 15-day period, the plaintiff loses the opportunity to apply for summary judgment. Number 2. The application for summary judgment must state that the application will be set down for hearing on a stated day. That day may not be less than 10 days from the date of the delivery of the application. This means that the defendant must be given at least 10 days' notice of the hearing. The plaintiff will obtain the date of the hearing from the registrar before serving the application on the defendant. Number 3. If the defendant responds by way of affidavit, this should be delivered by noon of the day but 1, preceding the hearing. That is, at least by noon 2 days before the hearing. Okay. Number 4. If the matter is not dealt with by the parties agreeing to the usual order, argument will be heard at the hearing. Number 5.3.4. The supporting affidavit. The notice of application must be supported by an affidavit deposed to by the plaintiff himself, or by any other person who is able to swear positively to the facts. It is not sufficient in cases where the deponent is a person other than the plaintiff for the deponent simply to state that he is able to swear positively to the facts. He must go further than this and state that the facts are within his own personal knowledge. Where no single person has knowledge of all the facts, affidavits by more than one person are required. If the affidavit is deposed to by someone acting in a representative capacity, such as the managing director of a company, the affidavit should also state that he has been duly authorized and this authorization needs to be obtained. In Rees and Another versus Investec Bank Limited, the Supreme Court of Appeal explained. The mere assertion by a deponent that he can swear positively to the facts, an assertion which merely reproduces the wording of the rule, is not regarded as being sufficient unless there are good grounds for believing that the deponent fully appreciated the meaning of these words. In my view, this is a salutary practice. While undue formalism in procedural matters is always to be eschewed, it is important in summary judgment applications under Rule 32 that, in substance, the plaintiff should do what is required of him by the rule. The extraordinary and drastic nature of the remedy of summary judgment in its present form has often been judicially emphasized. The grant of the remedy is based upon the supposition that the plaintiff's claim is unimpeachable and that the defendant's defense is bogus or bad in law. One of the aids to ensuring that this is the position is the affidavit filed in support of the application. And to achieve this end, it is important that the affidavit should be deposed to either by the plaintiff himself or by someone who has personal knowledge of the facts. Furthermore, in Shackleton Credit Management Proprietary Limited versus Microzone Trading 88 CC and Another, it was held that first-hand knowledge of every fact which goes to make up the applicant's cause of action is not required. And where the applicant is a corporate entity, the deponent may well legitimately rely on records in the company's possession for their personal knowledge of at least certain of the relevant facts and the ability to swear positively to such facts. The affidavit is a very simple one, but must comply with the provisions of Rule 32, subsection 2 of the High Court's Rules and Magistrates Court's Rule 14, subsection 2. In terms of these rules, the person making the affidavit must, first, verify the cause of action and the amount claimed, if any amount is claimed. Secondly, state that in his opinion there is no bona fide defense to the action, and lastly, state that notice of intention to defend has been delivered solely for the purpose of delay. From a practical point of view, the words above are literally all that the plaintiff need say in his affidavit, and it is advisable to stick very closely to the words used in the rule. Verify does not mean that he should provide any evidence in support of the allegations contained in the particulars of claim. If he does so, such evidence will be struck out. No annexures to the affidavit are permitted, except that where the claim is based on a liquid document, a copy must be annexed. Number 5.3.5. Responding to an application for summary judgment. In terms of Rule 32, subsection 3 of the High Court Rules and Magistrates Courts Rules 14, subsection 3, the defendant has two main options open to him upon receipt of the notice of application for summary judgment. Number 1. Give security to the plaintiff to the satisfaction of the registrar for any judgment, including costs which may be given. This response only applies to a money claim, of course, although it may also be used where the claim is supported by a money claim in the alternative. If the defendant adopts this course of action, the application for summary judgment will be defeated, and the action will proceed as normal. With this response, the defendant is showing that he is at least able to make payment. That inability to pay is not the reason for his defending the matter, and that the plaintiff will not ultimately suffer from the delay. The defendant is in effect putting his money where his mouth is. Security may be given by way of a bond of security obtained from a financial institution, or else the defendant's attorney may stand surety. The charges levied by financial institutions for bonds of security are prohibitive unless the defendant has fairly strong financial resources. An attorney would be foolish to stand surety unless he is placed in funds, or the defendant he is representing is a solid business or public institution. Number 2. Satisfy the court by affidavit or with the leave of the court by oral evidence that he has a bona fide defense to the action. The affidavit or oral evidence may be given by the defendant himself or by any other person who is able to swear positively to the fact that he has a bona fide defense. The affidavit or oral evidence must disclose fully the nature and grounds of the defense and the material facts relied upon for the defense. In other words, the defendant cannot get away with simply claiming that he has a valid defense. He must spell out in broad terms what that defense is. He does not, however, have to set out his defense in the same detail or provide evidence as will be required of him at the trial. At the summary judgment stage, the onus on the defendant is not to satisfy the court that his defense will probably succeed, but merely that the facts sketched by him, if proved at the trial, would constitute a possible defense to the plaintiff's claim. In other words, at the summary judgment stage, the court is not interested in whether the plaintiff's or the defendant's version of events is more probable. As long as the defendant's version, if proved true, would amount to a valid defense to the claim, it qualifies as a bona fide defense. The affidavit, therefore, need never provide more information than a plea. And as High Court Rule 18, subsection 4 will not apply. The defendant may even get away with less, provided that the nature and grounds of his defense are disclosed. In general, the defense raised must go to the merits of the application. Technical defenses are not permitted. This is the favorite method chosen by defendants for opposing summary judgment applications, as furnishing security will incur bank charges or require that funds be tied up until the close of trial. On the negative side, the defendant must hurriedly set out his defense in writing on oath. If he departs from the contents of the affidavit, either in the plea or later in the witness box at trial, the plaintiff's legal representatives are in possession of superb material with which to cross-examine him. If the defendant either gives security or satisfy the court that he has a bona fide defense, the court will give him leave to defend, and the matter will proceed as if there had been no application for the summary judgment. The time within which any further pleading must be filed is deemed to run from the date on which the court grants leave to defend. If the defendant does not provide security or satisfy the court that he has a bona fide defense, the court has the discretion to grant summary judgment against the defendant in favor of the plaintiff. Number 5.3.6. The court hearing. The plaintiff may adduce no evidence other than that contained in the affidavit accompanying his application. That affidavit, of course, provides no information that is not contained in the particulars of claim. Neither party is permitted to cross-examine any person who gives evidence viva voce, that is, orally, or by affidavit. This means that the hearing is restricted to an argument in relation to whether, having regard to the affidavits or oral evidence, the defendant has failed to disclose a bona fide defense. It can be seen then that in all the circumstances the odds are stacked against a court granting summary judgment. This is because summary judgment should not be granted lightly, and the courts will only deprive a defendant of the opportunity to defend in clear cases. The courts are cautious and conservative in this matter because the summary judgment procedure does infringe against the odi alterum partem rule to a certain extent. Number 5.3.7. The usual order. When summary judgment has been applied for and the plaintiff has received an affidavit from the defendant that discloses a defense, the plaintiff's attorney is likely to persist in attempting to obtain summary judgment. Usually, he will telephone the defendant's attorney to ask if he will agree that the usual order be requested by consent at the hearing. If the defendant's attorney agrees, only the plaintiff's attorney will attend court and will ask for the usual order by consent. The usual order in the in these circumstances means that number 1, summary judgment is refused, number 2, the defendant granted leave to defend, and third, costs to be reserved. Number 5.3.8 Special orders for costs. Generally, the court may make an order for costs that it seems to it to be just. If an application for summary judgment is opposed and then refused, the costs order awarded will usually be in the cause, although the court has discretion in the awarding of costs and may depart from the normal costs. If the application for summary judgment is granted, costs of the application will usually be awarded to the plaintiff. The alternative is that the parties agree to the usual order by consent, which means that costs will be reserved. A further alternative exists in terms of High Court Rule 32, subsection 9, and Magistrates Courts Rule 14, subsection 10, which provides specific guidelines for the ordering of attorney and client costs in certain situations pertaining to a summary judgment. Where the plaintiff makes an application that does not fall within the categories of claims listed in terms of Rule 32, subsection 1 of the High Court Rules and Magistrates Courts Rule 14, subsection 1, or where the plaintiff, in the opinion of the court, knew that the defendant was relying on a contention which would entitle him to leave to defend, the court may order that the action be stayed until the plaintiff has paid the defendant's costs. The court may, in addition, show its displeasure by granting attorney and client costs. This situation may arise if the plaintiff and his attorney know from correspondence with the defendant prior to the issue of summons that the defendant is going to allege the existence of a valid defense. The plaintiff may not agree with the validity of the defense, but the plaintiff's attorney ought to know that in the absence of evidence to the contrary, the defense as alleged is capable of overcoming a summary judgment application. In requesting attorney and client costs, and after setting out the nature and grounds of his defense in an affidavit, the defendant will usually proceed to allege that the plaintiff knew of the existence of this defense, and will annex copies of the correspondence which supports this contention. The purpose of this provision is to discourage tactical applications for summary judgments where the plaintiff does not really believe the defendant's claim to be bogus, but wishes to force the defendant to set out his defense on oath, which will provide his attorney with material for cross-examination at a later stage. Because of the need to balance the stringent nature of summary judgment against the defendant's right to a hearing, a summary judgment application is relatively easy to defeat. This is especially so if the defendant is willing to put forward a bogus defense in order to keep the plaintiff at bay. For this reason, Rule 32, subsection 9b of the High Court Rules and Magistrates Court Rules 14, subsection 10b deal with the situation in which summary judgment is refused, but it subsequently becomes clear at the trial that the defense put forward was bogus or unreasonable, and that summary judgment ought to have been granted. The court may show its displeasure with the defendant by ordering him to pay attorney and client costs for the entire action. Number 5.4 Shortcut Judgment 3 Consent and Confession to Judgment. Number 5.4.1 Judgment on Confession in the High Court. Rule 31. In terms of High Court Rule 31, subsection 1, a defendant may at any time confess to judgment in respect of the whole or part of the plaintiff's claim as contained in the summons. There are, however, exceptions to this principle. It is not permissible to confess to judgment in an action for relief in terms of the Divorce Act or in an action claiming nullity of marriage. Due to the highly personal nature of such claims, as well as their importance to the parties involved, because they affect the status of the parties, it is not desirable that such claims be granted without at least one of the parties appearing in court. The way in which a defendant confesses to the plaintiff's claim is by signing a written confession to judgment. Rule 31, subsection 1b makes it clear that the confession to judgment must, first, be signed by the defendant personally. Secondly, the defendant's signature must either, third, A. Be witnessed by his attorney, in other words, not an attorney acting for the plaintiff, or B. Be verified by an affidavit deposed to by the defendant himself. Once it is signed, the confession to judgment is delivered to the plaintiff. In terms of High Court Rule 31, subsection 1, the plaintiff may then apply in writing through the registrar to a judge for judgment in accordance with the confession. Notice to the defendant is not necessary. The defendant's confession to judgment and the plaintiff's written request for judgment are placed before a judge in chambers, who decides whether or not to grant the judgment. Once the defendant consents in writing to judgment, he cannot withdraw his consent. Where the plaintiff's claim is based on a single cause of action and the defendant confesses to judgment in respect of a part of the claim only, the plaintiff may not obtain judgment in accordance with the confession and must then proceed against the defendant in a separate action for the balance of the claim. The reason is that the defendant will raise a special plea of res judicata. In practice, a defendant will often agree to pay a plaintiff's claim in installments. The plaintiff will insist that the defendant signs a confession to judgment, but will agree not to take judgment unless the defendant defaults in any of his payments. The fact that the confession to judgment is subject to an agreement between the parties does not affect its status as a confession to judgment. Its status is also not affected by the fact that the plaintiff may be required to lead evidence as to the agreement between the parties in order to obtain judgment in terms of the confession. Hiram's notes as follows. Where the judge who deals with the application for judgment is aware, from the terms of the consent itself, that the confession may not be utilized by the plaintiff for the purpose of obtaining judgment unless the defendant has failed to comply with its terms, he may require to be satisfied by the plaintiff by means of an affidavit that the defendant has in fact failed to do so, and may require notice to be given to the defendant before granting judgment in terms of the confession. Number 5.4.2 Judgment by consent in the magistrate's courts. Rule 11. After summons has been issued in a magistrate's courts matter, the defendant may consent to judgment in terms of magistrate's courts Rule 11. In terms of Rule 11, subsection 1, a defendant has three options if he wants to consent to judgment before he has entered an appearance to defend the matter. Number 1. When the sheriff serves him with his copy of the summons and shows him the original summons, he can sign the consent to judgment, which will be included in the original summons. The sheriff will then take the original summons back to court. Number 2. He may sign the consent to judgment, which will be included in his copy of the summons, and lodge it with the clerk or registrar of the court. And third, he may draft his own consent to judgment, which is similar to the consent to judgment included in the summons. This consent to judgment must then be signed by himself and 2 witnesses, whose addresses must also be given. In terms of Rule 11, subsection 4, a defendant may consent to judgment after he has entered an appearance to defend a matter by drafting his own consent to judgment, which must be similar to the consent to judgment which appears on the summons. The consent need only be signed by himself or his attorney. By consenting to judgment in terms of Rule 11, the defendant is able to avoid the judgment costs which would be incurred if he allowed the plaintiff to take judgment by default. The defendant will, however, have judgment taken against him. A defendant may not consent to judgment with regards to actions for relief in terms of the Divorce Act 70 of 1979, however, nor actions for the nullity of a marriage. Note that payment into court, a procedure which was previously available as an alternative to consenting to judgment, has now been abolished. An offer to settle in terms of Rule 18 may be made instead.